Hi everyone, I'm Chuan Wee Meng, CEO of Singapore International Mediation Centre. Welcome. We're doing a series on addressing the dispute resolution challenges of Japanese companies doing business in ASEAN. In this episode, we'll be looking at upholding the bargain, responding to non-performance and other contractual problems. This is jointly produced by the ASEAN-Japan Centre, Singapore International Arbitration Centre, and the Singapore International Mediation Centre. So very happy to have you. And with us here, I'm very glad that we have an esteemed panel, starting with Mr. Hiroki Aoki-san from Nagashima, Ono, and Tsunematsu. I hope I got that right.
Yeah, perfect.
And next, I have Marina Chin, Senior Counsel from TKQP, and Mr. Minang Oh from Allen & Gladhill. In any business relationship, uncertainties such as delays, non-performance, and revisions in contract are inevitable. How should companies respond, particularly Japanese companies doing business in ASEAN countries?
Generally, my advice is to carefully find out whether such request such action is initiated in good faith or not. If the opponent party genuinely wants to resolve the issue facing with a difficult situation like this pandemic, it might be better to take some time to discuss amicably between the party without recourse to legal proceedings, because it is generally good to save the friendly relationship between the parties. But on the other hand, if it is not a genuine attempt and the opponent party appears to just to delay the performance or avoid their contractual obligations, my advice is to initiate the legal proceedings as soon as possible.
When you have a problem in a contractual relationship, those two words should remind you of two things, right? There's a contract, you've got rights and obligations, but there's also a relationship. So when there is a problem, question is, which do you focus on first? And we would say really focus first on the relationship. Speak to your counterparty. Is there something that can be worked out? Are you hearing an excuse or are you hearing a good explanation? If you're hearing an explanation, then it's time to sit down and collaborate and talk and work yourself out of this problem, because today they may have a problem, tomorrow it could be you in a situation. Right? But if you're hearing an excuse, then of course, you may then have to focus then on the rights and obligations under the contract and start to take a harder approach.
Are there steps companies can take to minimize contractual problems before they occur?
Yeah, this is certainly a very difficult question, and there is no perfect answer. But at least you should be aware before entering into any agreement, what is your rights and obligations under the applicable law. Recently, I had an arbitration case between Japanese party and the foreign party over a dispute arising from non-acceptance of the goods provided by the Japanese party to the foreign parties. The governing law was Singapore law. We got a favorable award for our Japanese client, but one of the difficulties in the arbitration was how to prove the actual damage suffered by our client. In Japan, if it were brought in the Japanese court generally orders that the sales price must be paid by the opponent in exchange for the delivery of the goods, which is generally enforceable in Japan. But as far as I understand, in Singapore or other common law jurisdictions, it is generally very difficult to enforce such kind of order involving a specific performance. And you have to prove what actual damage is, and which is not necessarily easy, especially where the cost information is confidential to the other parties. So one of the ways to cope with could have been to set out the liquidated damage clause in the contract in advance, but it might have been difficult, especially in the very beginning of the transaction. But at least I can say that you should be aware the potential risk under the applicable, what will be the real risk for you, and ask yourself whether you can accept it eventually if such risk is realized.
I think beyond drafting, there are of course other soft touches that will be important. So I think that in a lot of cases, be it Japanese or Koreans or investors from other countries, when they come into ASEAN, sometimes they may not fully understand the culture or the way things are done in that country. Sometimes there's a driving force in the company to say we just must invest, and so there's a bit of a rush. And once there's a bit of a rush, you may not have fully done your due diligence and you don't fully understand, but you know, big picture wise, this is a venture you want to get into. The truth is, the learning shouldn't stop. You should continue to learn about the country, learn how things work, understand your business partner better, because there's always a cultural issue, there's sometimes a communication issue, and often we see that some of these disputes also arise because of these communication issues, and sometimes lack of communication. I think I myself have experienced it, my clients have experienced it. You sit at a meeting and you think your counterparty understands because your counterparty is sitting there and nodding his head. But actually, he's not agreeing with you at all. He's just indicating that he's hearing what you're saying, but he doesn't necessarily agree. And so that there is actually that learning process that is important, and to continue to maintain relationships, and sometimes relationships at different levels of the company, right? Not just at the senior level. Middle management, the junior ones, if the two business partners have people at different levels continue to interact with each other and have that continuing conversation, then I think it brings the relationship a very long way, because it's meant to be a long-term one.
I would say 3 points that would be helpful for investors to bear in mind when they are investing into a particular country. First, get to know the country and the people and the system, how things work in that country. Second, choose a good partner, the right partner for yourself. And the right partner for you may not be the right partner for another investor. In terms of the partner, it is absolutely vital that you choose one that is right for you. It may be a very reputable company, very well established, but it may not just be the right fit for you. And you may want a certain type of company or a certain type of partner for the kind of investment that you're making. So in a heavily regulated segment, sector, for instance, you will want a partner that really understands the nuances of the rules, the regulations, and who can then navigate through that process so that you get your license done properly, you get your regulatory hurdles cleared in time. But in another area where it's a real estate investment, you may want a partner who has a very good piece of land. So different considerations, right, go into how you choose a partner. But I think the key is to try to get a partner that suits you, so that later on disputes don't arise. Third, have a well-drafted contract, especially with a good dispute resolution clause included, so that in the eventuality that you do get to a dispute, that there is no ambiguity as to how you should go about resolving that dispute.
Can arbitration and mediation help facilitate dissolution of a joint venture among Japanese companies and companies in Southeast Asia?
I would prefer to use the word resolution actually rather than dissolution, because hopefully dissolution comes as a last resort. But in terms of disputes, certainly I think mediation and arbitration would be perfect fora or mechanisms to resolve disputes for investments in Southeast Asia. And I think that if you have a good mediation clause, a good arbitration clause in the contract, certainly when disputes arise, you can refer to them and refer to the institutions that good institutions that would be written into the contract, hopefully, such as the SIMC, the SIAC, so that your dispute gets handled properly and you're able to bring your dispute to a proper and a satisfactory resolution.
There are two main advantages to arbitration and mediation. If you were resolving your matter in court, then you're in a public forum. Anyone can walk in, the press can report about your case. But when you have arbitration or mediation, you have two main advantages. One is confidentiality, right? It's all within the four walls. Whatever your problems may be, it is within those four walls. The second main advantage is that you have some say in your choice of mediator or arbitrator. And so you can find someone suitable, someone who perhaps understands the particular business or industry or country or can speak a particular language. And I find that there have been enough cases where the right mediator, including the mediator who can speak the right language, does help very much in reaching a happy conclusion for the mediation.
I have reviewed a lot of these joint venture agreement or M&A agreement, but sometimes it doesn't really include the proper exit mechanism. But I think the starting point is how the party may resolve under the contract. So it is very important to set out the proper exit mechanism in the agreement. It is very painful to discuss about how to divorce when you get married, but it is particularly important, especially in these international transactions.
What is your advice to Japanese companies with investments in Southeast Asia?
So mediation first, I think. That would be my recommendation. And arbitration if mediation cannot resolve the dispute, because the difference between arbitration and going to courts is that you're going to be able to choose your arbitrator who understands, or panel arbitrators who understand the issues, the business. Same with the mediator, as Marina has already mentioned. You get someone who can understand and who can empathize with you and see where you're coming from and help to resolve things faster in a more satisfactory manner.
Thank you for that. It's wonderful that we have representatives from Japan, Singapore, and Myanmar here representing the legal fraternity, not only in drafting the contract, but also in advising when you do have a problem. So with that, I want to thank you for your participation, for all your advice, and thank you for listening.